Welcome, everyone, to our virtual legal clinic. Our new series has started for the 2020-21 school year. We're happy from Say Yes Buffalo to be joined by our partners, the Volunteer Lawyers Project, to bring you another round of programming that is community needed and um, focusing on topics that are present today. Today's session will be Know Your Rights Housing, the COVID-19 edition, and we're happy to have two attorneys with us. But before we get into the presentation, we want to remind all our guests and participants that free legal advice is available through our partner, the Volunteer Lawyers Project. They can address any non-legal criminal issues, such as family law questions, housing questions, divorce-related issues, unemployment, and other types of cases. If you have any questions, please send us a comment in our chat box on Facebook, as we will present information to you again regarding housing. Gratefully, we have today Caitlin Niedermeyer and Christopher Siegel. Caitlin is a senior staff attorney with Neighborhood Legal Services, and Christopher is a housing attorney with the ECBA Volunteer Lawyers Project. So we're extremely excited to have both of them here today. Thank you, Caitlin and Chris, for joining us and bringing us this pertinent information for today. Caitlin, I'll turn it over to you to begin our presentation.
Thanks, Jelena. You can move to the first slide. We're glad to have you here today. We would definitely encourage you to ask questions as they come up. We'll try and get to them in real time, but if not, we'll definitely have time at the end for a question and answer session. So if you think of something that you want to have asked and you think of it after we pass that slide, maybe just jot a note down and we'll definitely have time at the end. We're going to talk about several things today. We're going to start with a COVID-19 update. There's been so much buzz about the CDC eviction moratorium, and there's been a little less buzz, but still some information about the New York State Tenant Safe Harbor Act, which is often referred to as the New York State ban on evictions. So we'll give you some more information about those topics and kind of clear up the confusion for you. We're also going to do an overview of hot topics in landlord-tenant law. These are things that we're asked about most frequently as attorneys. And then, like I said, at the end, we'll have that time for questions. Next slide, please. All right, working through our COVID-19 update. Just so you know, this information is up to date as of yesterday. So this includes all of the information we had through yesterday. We continually check executive orders and administrative orders that come from the state of New York. And we also check the federal legislation as changes come about. So this is definitely a fluid situation with new information coming about frequently. At our website for Neighborhood Legal Services, it's nls.org. We have a document called What We Know about evictions, and we update that all the time. So if you're ever trying to find the most recent information, we usually update that within a day of anything new coming down. So you can head to our website to check that out. Next slide, please. The CDC moratorium on evictions is really a temporary ban on residential evictions. So what this means is that most evictions cannot take place between September 4th and December 31st of this year. This ban on evictions is not complete, so there are still some exceptions. Landlords can still evict tenants who are engaged in criminal activity, or tenants who pose a health or safety risk to other tenants at the property or to the property itself. But it mostly prohibits evictions from, again, September 4th through December 31st, 2020. This federal moratorium, the ban, it doesn't say that tenants don't have to pay rent. And it also doesn't prevent a landlord from charging late fees. So if you are a tenant and you can pay your rent or you can pay part of your rent, we would definitely encourage you to do so, because if your landlord is trying to charge late fees, according to the CDC guidance, he or she may be able to. What you see in the law is you keep seeing this language about covered person. Covered person really just means any tenant or a lessee or a resident who fills out the declaration and gives it to their landlord or whoever has the right to bring an eviction. So for those of you who rent, you may not deal with your landlord. You might deal with a property manager or someone else who comes to collect the rent and you're not even sure what their title is. If you feel that you're protected under the CDC moratorium, and we're going to talk a little bit about the criteria for that in a minute, you can give that declaration to any of those people, and that's sufficient. That's enough. Next slide, please. So that declaration that I mentioned, it's just a written statement and it's already typed up by the CDC. So we have this form available on our website, and you can also find it if you just want to Google by Googling CDC moratorium form, and it'll pop right up. What the declaration does is give tenants who have been affected by COVID financially a way to tell their landlord that they're protected from being evicted. In order to bring the CDC moratorium up as a defense, the tenant has to meet 5 requirements. So 2 of them are on this slide, and 3 of them are on the next slide. And also, please don't worry about trying to memorize this information or rapid read these materials. They're all going to be made accessible to you, so you don't have to panic and try and remember, write everything down. The first requirement is that the tenant has tried to get all available government assistance for rent. What that means is the tenant has applied for emergency rent arrears from the Department of Social Services, or the tenant has applied for federal rent relief money that comes through the CARES Act. As we continue on in the pandemic and more funding becomes available for rent arrears, more agencies will start putting out applications for tenants who need to access that money. So before giving the declaration to your landlord, if you're a renter that says, I've tried to obtain this assistance, you want to make sure you're putting in applications for that money if you're behind on the rent. The second requirement is that the tenant doesn't expect to earn $99,000 or more in 2020. It's a very high income threshold. Most people who have fallen behind on rent arrears, and honestly, most people in general, are not going to individually earn $99,000 this year, especially if they've faced a COVID-related financial hardship. Next slide, please. The third requirement is that the tenant says or states that he or she and the family cannot pay the full rent because they've either had a substantial loss in income because their hours at work got cut or lost their job, or they've had an extraordinary out-of-pocket medical expense. This is probably the most important criteria on the list. If a tenant has not had a loss in income, but has just had a hard time paying the bills, the tenant won't be eligible to use the CDC ban as a defense. So it's very important that the tenant be able to state that there's a big loss in income and that it's because of a reduction in hours at work, or because the tenant was laid off or furloughed, or just had a severe decrease in hours due to COVID-19. If a tenant hasn't had those, but a tenant has had a great out-of-pocket medical expense, something very different than the tenant's normal medical expenses, that will also satisfy this number 3 criteria. The fourth criteria is that the tenant has made as many efforts as possible to make some payment to the landlord. And this is based on what the tenant can afford. So if the tenant's income was cut from $600 a month to $300 a month, and the rent is $500 a month, if all the tenant can pay is $100, then that's all the tenant can pay. And just showing that the tenant has made those payments of $100 in good faith is enough to satisfy that fourth criteria. And the last criteria is that if the tenant and the tenant's family are evicted, there would be a likelihood that they would have to live with family and friends, or else they'd be homeless. Next slide, please. And Chris is going to talk to you about the Tenant Safe Harbor Act, which is New York's ban on evictions.
Good afternoon, everybody. So the Tenant Safe Harbor Act is one of New York State's responses in some ways, it's very similar to the CDC moratorium that Caitlin was just talking about. But it was passed recently in July, and it says that courts may not issue a warrant of eviction or possession of judgment in eviction cases. Essentially, it's saying that you won't be put out of your home if you're unable to pay your rent, but it doesn't do anything to cancel the rent or relieve you of any other obligations. So the period that the Tenant Safe Harbor Act covers begins March 7th, and it runs until essentially 6 months after all of the New York State restrictions that have been put in place to protect the public health are lifted. So at the very earliest, it'll be, actually at this point, it'll be later than January 1st, 2020, because those restrictions are still in place and there's not any indication that they're going to be lifted anytime soon. So at very least 6 months from now, we can go to the next slide. The main provision of the Safe Harbor Act is that financial hardship can be a defense in non-payment eviction proceedings. Now, a little bit later, we'll get into a little bit more about the different kind of proceedings. There are non-payment and others, but this act only applies to non-payment, to tenants that haven't or have been unable to pay their landlord. So there are several factors listed there that the court is supposed to look at to determine if you've suffered a financial hardship, and the financial hardship has to be related to the coronavirus pandemic. So like with the CDC order, if you've lost your job or lost hours or had unusual expenses, those things can be included here. And then just recently, Governor Cuomo issued an executive order that expands the Safe Harbor Act to apply to tenants who were served with eviction warrants before that March 7th date. So it doesn't, it covers some cases that were in the courts and got put on hold when everything was shut down. Those cases are still out there and still kicking around, and people haven't known what to do with them or about them. There was some indication recently that those warrants would be, those cases would be moving forward starting on October 1st. But just before that, the Safe Harbor Act was expanded to cover some of them. So any non-payment evictions where a warrant was served before that March 7th date are still covered by this, and those tenants are still able to raise financial hardship as a defense. We can go to the next slide. So the Safe Harbor Act doesn't relieve your obligation to do anything that's in the lease to pay your rent. It just protects you from eviction. So it's a defense that can be raised in the case, but even though the landlord doesn't get a warrant of eviction, they could still get a money judgment, which is a judgment from the court that a certain amount of money is due, the back rent. And again, that a tenant can't be ordered out, can't be actually evicted until the covered period ends, which, as somebody pointed out, the earliest would be January 2021. But again, that's the earliest date, and it can be 6 months. If there are restrictions from the state still in place, it will be 6 months after those restrictions are finally lifted. If a tenant had a financial hardship during the covered period, but it wasn't related to the coronavirus. Actually, I'm sorry. That's that's not right. If you did not suffer a financial hardship, but you still didn't pay rent, then the Tenant Safe Harbor Act won't be a successful defense for you. You'll have to be able to show that you had this hardship and that you actually lost income. This is the slide mentions the October 1st date that I was talking about. The court system had made a rule essentially that they weren't going to let eviction warrants be served or executed before October 1st. That's come and gone, so theoretically that can happen now. An eviction warrant can be served, and again, that's something we'll get into a little bit more later on. We can go ahead 2 slides actually. So we're going to get into some of the hot topics, the questions people ask a lot, and the big changes that have happened recently in landlord-tenant law. The Tenant Protection Act, which went into effect in the summer of 2019, is another New York state law that made pretty sweeping changes to all of the old rules. So if you have a passing familiarity, if you've ever been through an eviction before, or if you just know something about it, if you've ever heard somebody talk about a 3-day pay or quit notice or a 72-hour notice on your door from the marshals, those things have changed. So one of the big provisions here is that if you are behind on your rent, your landlord has to give you a 14-day notice saying you have to pay your rent or you have to get out of the apartment. It has to be written and it has to be served before they can go to court and file a non-payment eviction proceedings. There are other provisions in this law that sort of clean up the landlord's responsibilities. Landlords now affirmatively have a responsibility to provide written receipts for payments when they receive them. The definition of what rent is, which, believe it or not, is something people used to be able to argue about, has been clarified. If a tenant defaults, that is, if they don't show up to court, despite being served with the court papers and notified that there's an eviction proceeding, the landlord used to be able to get a default, a money judgment against them. They'd get a default judgment that says you win because nobody showed up to disagree, to argue the other side. And they used to, in some situations, be able to get a money judgment. Now that can't happen if a tenant defaults and doesn't show up to the court date. We can go to the next slide. Late fees are another thing that has changed. They're limited now, so they can only be charged when the rent is more than 5 days late. And they can only be $50 or 5% of the monthly rent, whichever one is less. So if you have any experience being charged late fees, this is probably more in your favor, more generous than the fees you've had to pay before. In addition, rent has been defined so that rent is the only thing that can be included in the non-payment eviction proceeding, not late fees or other charges, other things that a landlord could tack on to make it actually harder for a tenant to pay. We can go to the next slide.
Chris, I'm seeing a question in the chat that I can just answer quickly. The question is, for those of you who can't see the Zoom chat, the question is, if a tenant defaults, doesn't show up to court after being served, what happens then? So what Chris was describing on the last slide, that money judgment can no longer be issued, it doesn't mean that a judgment for possession can't be issued. So generally what happens if a tenant defaults is that the court would issue a default judgment for possession, meaning the landlord can take possession of the property again. but not a default money judgment, meaning the landlord won't be awarded any costs or fees.
Excellent, thank you. So there are other changes noted on this slide about the timelines for when a petition has to be served, which is the court paperwork that you actually get that explains what the landlord is what they say you did wrong, what amount of rent you didn't pay for what dates, and is served with a notice that tells you when to be at court. The dates are on here, but if you get served with paperwork and you have a question about it, I'd urge you to reach out through the resources at either NLS or VLP. And I think the documents provided by Say Yes can help direct you to the right place. There are also there's also a provision that was added so that if a tenant requests a 14-day adjournment, if there is an issue of fact. So if a tenant says they paid the rent, but they don't have the proof with them, the landlord says you never paid it, and the tenant knows they have the receipt, you know, it's at their home in their bedroom, then the rules have been slightly loosened to give you time, 14 days to reschedule the court date and come back a second time. So court is and will probably always be a intimidating, sometimes scary thing. And it's even worse when you feel like it's a one-shot deal. You have a couple of minutes to plead your case and that's it. But if there's a legitimate question of fact, you get more than just that couple of minutes before the judge. We can go to the next slide. And Caitlin?
Yep. And I'm going to address another question in the Zoom chat. The question is, in the absence of a default monetary judgment, is small claims court the only avenue to receive rent? Generally, the answer to that is yes. Small claims court does have a monetary limit of $5,000 inside the city of Buffalo. So if the rent and or damage to the property exceed $5,000, then you're actually moving into city court outside of small claims court. But generally, small claims court is the landlord's mechanism to sue for any back owed rent. Okay. One of the biggest changes in the Tenant Protection Act is that a warrant cannot execute sooner than 14 calendar days from the date it is served. So like Chris mentioned before, if you unfortunately had the experience of going through an eviction or know someone who went through an eviction, you're aware that it was 3 days. You would get a red slip of paper or a yellow slip of paper on your door, and 3 days later, the marshals could come out and remove you and have the locks changed. That is now 14 calendar days. Another defense that's built in is if a tenant can pay the rent that's owed before that warrant executes, the tenant can bring the money to court and the warrant will be vacated, meaning the warrant goes away. So sometimes we had non-payment eviction proceedings, meaning your landlord brought you to court because you haven't paid the rent that you owe and you really just needed one more week and you could have had all of it. In this case, now under the Tenant Protection Act, if you have that rent money, you bring it to the court the next week and the warrant does go away. There are sometimes disputes about how much rent is owed. At that court date, the judge and the court are going to determine how much back rent is owed, and they're going to write it down on the judgment sheet. So if you do attempt to pay the back rent to avoid the warrant executing, to avoid the marshals coming back out, the court is going to have the amount on the judgment sheet that you owe. So you could always ask the court if you're not sure, and you would want to make sure you pay that amount in whole if you're trying to make sure the warrant doesn't execute, because a partial payment won't keep the warrant from executing. The warrant will still execute if you can pay, 3/4 of it. A tenant can also now request something called an extreme hardship stay after the issuance of the warrant. And again, the issuance of the warrant is when it's posted on the door. The execution is when the marshals come back to remove the tenants. So after there's been an issuance of a warrant, if the tenant has an extreme hardship, they can ask the court to hold off on the execution of the warrant. This is only applicable in very rare cases. So I don't want to give the impression that this is widely used. When I say extreme, it means very extreme. So things that haven't fallen under this are having children in school or a lack of affordable housing. Those things are all very relevant and legitimate hardships, but generally they're not going to qualify for an extreme hardship stay. Now, we're not quite sure how this extreme hardship stay defense is going to play out in terms of the pandemic. We do know that there's even less affordable housing now than there has been in the past. And we do know that many people, especially renters, have had a substantial loss of income that's truly preventing them from finding any place to live. So it may be that courts look at this defense and apply it a little more freely, a little more liberally, but we're just not sure because there have not been that many eviction cases heard since the pandemic began. And it's important to note too that the extreme hardship stay, this defense require, not a defense, I guess, the stay request requires that the tenant deposit the rent decided by the court in order to stay that warrant. So that means that the whole time the court is saying, okay, you're being evicted, but not quite yet, you do have to go ahead and pay the rent to the court or the landlord, the court would tell you which, in order to keep the warrant from executing. Next slide, please. Okay, if there is a utility shutoff, so we're talking about gas, electric, water, and it's due to the landlord's failure, or it's an action directly by the landlord, in an unfortunate instance of self-help, any summary proceedings, that's an eviction proceeding, will be stayed until such time that the utilities are restored. This means that if your landlord takes you to court for an eviction proceeding, but because you haven't paid your rent, your landlord cut off your water, the court won't hear your eviction case until the landlord restores your water. There are other penalties that can be instituted as well, but the primary thing that you should know if you're being brought to eviction court or if a friend or family member is being brought is that if the landlord has turned off your utilities or the landlord has refused to pay utility bills for which he's responsible, the landlord can't maintain an eviction proceeding. It gets put on hold until your utilities are back. This doesn't apply if you have a lease that specifies that you as a tenant are responsible for heat or water or gas, electric costs, and you don't pay those bills. This is just for landlord failure. A separate provision is that security deposits cannot exceed 1 month's rent. So you might have seen ads in the past, and you honestly might see them now, that say rent is $750 a month and security deposit is $1,400. The landlord can't charge $1,400. The landlord can only charge 1 month's rent. So in that scenario, the security deposit would be limited to $750. Also, when a tenant vacates, a landlord used to have what was called a reasonable amount of time to return the security deposit. There were different interpretations of that, but generally it was considered to be about 30 days. Now, under the Tenant Protection Act, security deposits have to be returned within 14 days of the tenant leaving. The landlord can still take away any part of the security deposit to cover damage that's worse than wear and tear, unpaid rent, utilities charged to the landlord, or moving and storage of tenants' belongings. That being said, if the landlord does not return a portion of the rent, the landlord has to give an itemized list to the tenant stating, does not return a portion of the security deposit. The landlord has to give an itemized list to the tenant stating what part of the security deposit was withheld. Next slide, please. Landlords have to provide tenants the opportunity to inspect a unit after lease signing and before occupancy. So After a tenant signs a lease, sometimes the landlord says, we're going to have you sign this lease and then you can see the unit. I'll show you a model unit. And then after you sign a lease, I'll take you to your unit. You as a tenant have to be able to see your unit after you sign the lease and before you take occupancy. If you do that inspection and you do it with your landlord, you and your landlord should put down what you see and what you agree upon in writing. This is the best chance to avoid disputes later about the condition of the apartment or the house and whether your landlord has the right to retain some of your security deposit. A landlord cannot keep a part of the security deposit for conditions that are listed in this inspection report. So when the landlord and the tenant do this, it really protects both of them. This is the chance for the landlord to document, this is the conditions of the apartment as it is. There are no damages here. These are pictures of what it is. And this is the chance for the tenant to say, well, actually, there's a slight defect here, or I want to make sure I'm not held responsible for this. And then this writing is what both parties will have if there's a dispute or a disagreement when the tenant moves out. I'm seeing another question in the group chat. Can a landlord still ask for first month's rent, last month's rent, and security deposit in advance? Under the Tenant Protection Act, landlords are limited to asking for first month's rent and a security deposit, but they are not supposed to ask for any other advance on the rent. So last month's rent is an advance on the rent that's owed. Generally, that would not be considered legal under the Tenant Protection Act. Next slide, please. Landlords must notify the tenant of a tenant's right to request an inspection before leaving. So the tenant has a right to say to the landlord, I'd like to have you come inspect this property. Let's do this together before I go. Let's look at the condition of the premises. Let's see if there's any damages. Do we agree on, the condition of the apartment? And if the tenant does that, the landlord then should give 48 hours written notice of the date and time of the inspection. And again, I would really encourage all parties to do this together, tenants and landlords to do this inspection together so that you have a chance to resolve any issues regarding the condition of the apartment without having to go to court. Perhaps there are some holes in the wall that could be spackled by the tenant or spackled by the landlord, and it could be for a nominal fee instead of everyone going to court to dispute what the condition was and how much money it was worth. A lot of times there are very minor issues that can just be resolved by talking to each other instead. Next slide, please. There's a portion of the Tenant Protection Act that we call the 30-60-90 rule. This is a portion of the Tenant Protection Act that changes the amount of notice you get as a tenant if your rent is increasing by 5% or more, if your lease is not going to be renewed, or if your month-to-month tenancy is going to be terminated. So I know that's a lot. It's a mouthful and it's a lot of information. The three conditions, again, that this applies to are if your rent is increasing by 5% or more, if your lease is not going to be renewed, or if your month-to-month tenancy will be terminated. If a tenant has been in a unit for less than 1 year and has a lease term of less than 1 year, the 30-day notice rule under the old law is still the same. The tenant gets 30 days notice if any of these things are going to occur. If a tenant has been in a unit for more than 1 year, but less than 2 years, or has a lease term that was more than 1 year, but less than 2 years, that tenant gets 60 days notice. So previously, if a tenant had a month-to-month tenancy and the landlord wanted to end it, the landlord could say, here's a 30-day notice. You need to be out in 30 days. Now, in a situation where a tenant's lived there for a whole year and the landlord's saying, oh gosh, I need to get this tenant out, the landlord has to give 60 days. Same thing if the landlord wants to raise the rent by 5% or more. And finally, where the tenant has been in the unit for more than 2 years or has a lease term of at least 2 years, the tenant receives 90 days written notice before a rent increase of 5% or more if the lease is not going to be renewed or if the month-to-month tenancy is going to be terminated. There are a couple situations that I've seen recently where leases say something different than what's outlined in the Tenant Protection Act. Most recently, I saw a lease that said, if we are not going to renew your lease, we will give you 60 days notice. The person whose lease I was reviewing had been a tenant for 5 years. So under this 30, 60, 90 rule, 60 days notice isn't enough time to notify the tenant that the lease won't be renewed. That tenant's entitled to 90 days. So even if the language in the lease says otherwise, it's this 30, 60, 90 rule that still applies. And again, because this can be dense and because this is questions about your lease, breaking your lease, the language, how much notice you should get for something, please reach out to Neighborhood Legal Services or Volunteer Lawyer Project. We are happy to look into this for you. We're happy to review your lease and see what the conditions are that the landlord has imposed and how they play out for you. I'm seeing a question in the group chat and Zoom. What should tenants do if there's a rent increase and their income has been compromised due to COVID-19? Are there any protections? So there are no changes in the law in terms of a landlord's ability to impose a rent increase as a result of a COVID financial hardship. So even if a tenant has suffered a COVID financial hardship, a landlord is still able to raise the rent in accordance with this notice rule. So if it's more than 5%, 30, 60, or 90 days, depending on how long the tenant has lived at the property. If a tenant cannot pay the increased rent, the tenant should just pay as much of the rent as possible, because that's part of the defense that's necessary under the CDC moratorium, and it's an important consideration under the New York's Tenant Safe Harbor Act, that the tenant is showing that there's a financial hardship and that the tenant is making these payments to the best of the tenant's ability. Next slide, please. We're going to go into some frequently asked questions now. And if you have questions, keep dropping them in the chat or on Facebook Live. We're getting those transferred over to us a little behind real time, but go ahead and keep dropping them in and we'll get answers for you.
Okay, we can go to the next slide, please. So the first question here, what's the difference between a non-payment eviction and a holdover eviction? So these are kind of funny legal terms, holdover especially, that you never see anywhere else. But essentially, a non-payment action or proceeding is an eviction action based on the tenant's failure to pay the rent that was agreed upon. So the notices I talked about earlier, you get a 14-day demand to pay the rent, which affects the timeline. You only have 14 days to pay the rent, or else the landlord can commence an eviction action. A holdover proceeding involves a tenant who's staying at the property beyond their right to do so. So if you have a lease that expires after 1 year and that year passes by, your lease isn't renewed and you don't leave, your landlord could bring a holdover eviction action against you. Similarly, if you don't have a lease and you're a month-to-month tenant, but your landlord has already given you notice that they want to terminate your month-to-month tenancy, then you're staying at the property beyond the time period that you should. And the notices required for that, Caitlin went over. Those have that 30, 60, 90-day rule. And obviously, if you get 90 days, it affects the timeline. You have a little bit more time to find a new place if that's what you're going to do, or work it out with your landlord. We can go to the next slide. So what can a tenant do if there are bad conditions in their homes? This is a very common question. And it can be a tough question because there's a lot of there are a lot of subjective factors involved. But broadly speaking, every single lease or rental agreement in New York State, so every single landlord-tenant relationship, residential landlord-tenant relationship, includes something called the implied warranty of habitability. It's a warranty, a promise, like a warranty on a car. You know, the manufacturer is promising that nothing's going to break because it's new. It's implied, which means it doesn't have to be written, doesn't have to be spoken. It's always there. It's always required by New York State law, and it cannot be waived. Habitability refers to the apartment being a safe and decent place to live, a place that you can that is habitable. I'll get into the specifics of what that means in just on the next slide. But because this promise, this implied promise, is always required, a landlord can't make you sign something, sign a lease or other agreement that you're renting the apartment as is, or that you're waiving any rights that you have here. New York State law says that portion of the lease or that agreement, if it's a separate agreement, will be void. It is just as if it didn't exist.
I'm seeing a question in the chat here, Chris, if I can interrupt you quickly. Oh, two of them. Okay, so the first one, can a landlord deny renting to a tenant if they do not want to make repairs? That's a tricky question. Generally, a landlord has the right to maintain their property how they see fit, so long as that doesn't obviously conflict with building codes, public safety issues. If the building code inspector or the health department comes out and issues a violation, the landlord would have to correct those things regardless of whether a tenant is at the property. But if there's a significant repair needed, and we're talking about a condition that does affect life, health, and safety, the landlord shouldn't try to find a tenant who will accept that condition. The landlord should wait to rent until that condition is fixed.
If we could go to the next slide, I think that will help answer the question. So the conditions that we're talking about here are more serious than cosmetic repairs. If you have an ugly porch, or you have a house that needs to be painted, or any one of a million other things that don't affect the tenant's life or health or safety, then those are repairs that a landlord would not have to make. But if there is an infestation of rats, if there are bed bugs, if there's no heat, if there are electrical wires hanging, exposed electrical wires hanging from the ceiling, or there are no utilities available, then a landlord, shouldn't be renting to anybody, and no tenant should be accepting an apartment in those circumstances, in that condition. There's a second question here. Is a landlord allowed to keep part of a security deposit to satisfy rent arrears?
Yeah, the answer to that question is no. And actually, I think that was confusing on an earlier slide. A landlord cannot keep part of a security deposit to satisfy rent arrears. Another question earlier asked about an avenue to receive rent, and that was where a tenant defaulted. Regardless of whether the tenant defaults in court or the action doesn't go to court, a landlord can no longer hold back part of a security deposit to satisfy rent arrears. The landlord does need to go through the court system to recoup that. I see a question too. What if you learn that there is lead paint? As a landlord, if you learn that there's lead paint, you should go to the Erie County website and look into the lead remediation information provided by the Department of Health. You would want to get that remediated before you rent to any tenants. As a tenant, if you learn that there is lead paint in your unit or your apartment, you should talk to your landlord as soon as possible, especially if you have small children. There's no safe amount of lead for a small child to be exposed to, and it can cause significant problems for children who do accidentally ingest it. The tricky thing about lead is that it's not something that can be cleaned up by an ordinary person. It's not like the dust on the floor that comes because you have forced air and, some dust blows around. Lead dust is very hard to contain, and every time you move it by sweeping or running a Swiffer over it, you're moving it around into the air more and actually increasing the risk that someone will ingest those lead particles and suffer harm. So lead always needs to be corrected by someone who's been trained in lead remediation. So talk with your landlord. If you're a tenant, if your landlord isn't willing to do anything, call the health department. And if you're a landlord, again, check out that county website, the county health website, because there are resources there about lead remediation. And then a couple more questions. Chris, do you want to take the mold and leaky roofs?
Sure. And before I do, I just wanted to add one more thing about lead. It depends on the conditions. So if you have small children, lead is always dangerous. If you have flaking lead paint that's falling on the floor and creating that lead dust, that is a much more serious condition. But if there is lead paint present, but it's in good condition and it's not falling all over the floor, that's less dangerous anyways. And oftentimes it's safer to leave it than to try and repair it yourself. If it's left alone or addressed by a professional, that's better than scraping and sanding yourself, exposing yourself and the tenants to lead.
Absolutely.
So as far as the warranty of habitability, do mold and leaky roofs qualify? They can. Not always. A small leak coming from a kitchen sink and getting the floor wet is not a danger to your health or safety. But if there is a gaping hole in the roof and the ceiling inside is sagging and growing mold, and if you get that mold tested and find out that it is dangerous to people, then that's certainly more likely. But it depends on the situation. It depends on the specific circumstances.
Then that next question that we have on the Zoom chat is, the slide states if it has not been caused by the tenant, so if the condition that's not safe, if it hasn't been caused by the tenant. But what do we do if a landlord blames the tenant for the issue and the tenant can't prove otherwise? Say if the landlord states the tenant brought the roaches or the bed bugs. This happens sometimes, that there are disputes between landlords and tenants over the source of the issue. When you're talking about a condition like a roach infestation or a bed bug infestation, it is the landlord's responsibility to correct the problem. The landlord has to exterminate or pay for an exterminator. Whether that cost can be passed on to the tenant is a separate issue. So even if the landlord is correct that the tenant did bring the bed bugs, or is correct that the tenant's behavior has resulted in an infestation, the landlord still has to remediate that condition, has to call out the exterminator, and then the landlord can try to pass on the cost to the tenant. In the situation that's brought up in the question, where the landlord states the tenant brought the roaches or the bed bugs, but the tenant didn't, it's going to be up to a court to decide who should pay for those extermination fees and who should pay for those costs. The landlord would have to take the tenant to small claims court to try to recover for those costs. And if the landlord does that, then both the tenant and landlord would bring their proof showing who they believed caused the condition, and the court would decide who should bear the cost of the extermination or those other repairs. Sorry, a couple more. If the landlord has a professional exterminator for rodents, and the company indicates that the tenant is causing infection by their actions, this is no longer a blame game. So that's one analysis of how it works. Again, it's always going to go through the court system to decide if a landlord is trying to get that money for repairs from a tenant. So both sides will just bring whatever documentation or pictures or other proof that they have, and then the court would decide. And then another question.
If I could, If I could just add a note, somebody asked earlier, how do you prove it's not caused by the tenant? That's the question, is getting the question backwards. The landlord has a responsibility to provide an apartment that is safe and habitable and not dangerous. So the question isn't how do you prove that it wasn't the tenant. That only becomes relevant if you can prove that it was the tenant that created it. The landlord has to fix it either way.
So another question we have is about rental units that are unsafe. Tenants who are fearful that they will lose their homes, so they feel that they have to rent unsafe premises. But why isn't there a mechanism for inspecting units before rental? There is now the right to inspect a unit before you take possession. So that's something new that came about as a result of the Tenant Protection Act. And the other thing that comes about as a result of the warranty of habitability is that a tenant doesn't rent a unit as is. So while you can't necessarily prevent the situation where you as a tenant enter an apartment and then it needs major repairs and the landlord doesn't make them, you do have rights in that situation to kind of help you either get into a new unit or encourage your landlord to make repairs. And we're going to talk about that in the next couple slides. But one of those rights that you have is specifically withholding your rent. Just about your question about inspection though, there's no general scheme where a third party would come out and inspect the unit before renting, unless you receive some sort of subsidy like a Section 8 benefit, or you receive money from a third party who gives the money on the condition that the unit pass an inspection.
Okay, Caitlin's going to take over here.
Sorry, how can a non-Section 8 tenant force the landlord to make repairs? And there's an asterisk right there next to Section 8, because if you are a Section 8 tenant, you should contact your caseworker and ask for an emergency inspection so that Section 8 can come out and send an inspector out to look at the conditions of your unit and get in touch with the landlord directly. Section 8 tenants should not withhold rent until they talk to their case manager in the Section 8 office about that. So if you're a Section 8 recipient and you receive assistance through Belmont, you'd contact your Belmont worker. RAC, contact your rental assistance worker. But if a non-Section 8 tenant wants to push the landlord to make repairs, the tenant should tell the landlord about all of these conditions that need to be fixed. And the tenant should do this in writing. So I always get the question, is it okay if I text him? Is it okay if I call her? It's much better to put it in a letter, but if you can't put it in a letter because you don't have your landlord's address or something else is preventing you from getting to the post office, it's better than nothing to send a text or an email. And what you should do is say, these are the conditions in my apartment that I feel are affecting my health, affecting my safety. I first brought this to your attention on this date. What I have to do as a result of this condition is this. So as a result of this condition, I can't use one room in my apartment, or as a result of this condition, having no hot water, my kids and I have to shower at the neighbor's house. And then the letter or the email should also include a request that the landlord fix the problem. The tenant can ask the landlord to fix it by a certain date, and it has to be a reasonable time frame. So if it's a condition that's, is causing a danger, but it's going to take a little while to get a repairman out, the court is going to understand that, landlords are working within the same parameters as anyone else as homeowners when it comes to getting somebody out to look at a property. So you might not be able to get a plumber out same day, might not be able to get a furnace fixed same day. But as long as the landlord's making diligent efforts to get someone out to address the problem, that's going to be considered okay. Next slide, please. What if a landlord is retaliating against a tenant for contacting the health inspector? The Tenant Protection Act specifically says that if a tenant files a complaint about the conditions of their apartment or their house to their landlord or the landlord's agent or a different agency, and then the landlord turns around and files an eviction case within 1 year, there's something called a rebuttable presumption of a retaliatory eviction. So landlords, this doesn't mean that if you file an eviction action within a year of a tenant complaining, the tenant will automatically not be evicted. There's nothing you can do to evict the tenant. What this means is that the court will presume that the eviction is retaliatory, and the landlord will then have the burden of showing the court that this is not retaliatory, that there's a valid reason for the eviction. Perhaps the valid reason is that there have been numerous lease violations, or perhaps there's been a failure to pay rent for several months. So this doesn't mean that the tenant has an absolute defense or the landlord is completely unable to remove the tenant. It just means that there's a presumption, if the eviction action is brought within 1 year of the complaint, that it's in retaliation. Again, retaliation is a very weak defense for a tenant where a tenant owes rent, especially if the client owes rent and has not saved the money. So part of the warranty of habitability, if you want to withhold rent from your landlord, requires that you save that rent money. It's not a good defense if a tenant shows up to court and says, I would pay the rent if these conditions were fixed, but I don't have the rent. That looks like I'm not going to pay the rent regardless. So it's something to consider when you're withholding rent, to make sure that you save that rent, and to know that this defense of retaliation isn't going to be very successful if there's no rent money saved. There's a question in the chat. How long should a tenant wait for the repairs to be made before withholding rent payments? I would say that's a really situation specific answer. So if a tenant is without heat in winter and the landlord isn't making the repair, it's reasonable to start withholding rent relatively quickly. If there is a less significant repair that's needed, the tenant should wait a little longer. It's really hard to give a hard and fast rule about that. It's definitely just going to depend on the repair that's needed, how long it generally takes to get that repair made, and how that condition is negatively affecting the tenant. So are we talking about a minor inconvenience, or like I mentioned before, no heat in the winter? And also some repairs, are things that can be dealt with by the landlord. Other repairs require a professional. Obviously, it's going to take more time if the landlord has to bring in a professional. And so then it's likely that the tenant should wait a little longer before withholding the rent.
One more thing is, it would depend on what you've said in your communication to the landlord. So if you haven't given them any warning, any notice, you should wait a little bit longer. But if you've already sent them a letter that details the conditions, details why it's a problem, and says, I will begin withholding my rent in 2 months, then that's a timeline.
All right, next slide, please. Okay, one common misconception that we hear is the court has to give me 30 days to move, or sometimes a tenant will come into an eviction proceeding and be told to move faster and say, doesn't the court have to give me 30 days to move? A warrant of eviction can execute 14 days from the date it was served. So again, the date of service is the date that it's posted on your door, and the execution is the day that the marshals come out to remove you or the tenants. That warrant of eviction can be posted and served the date after the court date. So if you have a court date on the 1st of the month for the previous month's rent, and the court decides that the landlord is getting a warrant of eviction and is getting a judgment of possession, if your landlord buys the warrant the same day and it's served the next day, the 2nd, you only have 2 weeks after that to vacate. There's no automatic rule of 30 days to move. It's also rare for attorneys to be able to negotiate a really long stay like that for a tenant facing eviction, unless there are other circumstances at play. So tenants shouldn't assume they get 30 days to move. They should only assume that they get the 14 days required under the Tenant Protection Act. I'm sorry, I'm looking at the chat for a question. If the tenants make repairs or paid for severe repairs to be done, can they withdraw from paying rent or substitute the repairs as payments? That's a great question. So sometimes a lease will be very specific about that. It might say a tenant must contact the landlord and give landlord 24 hours to make repairs before deducting from the rent or before trying to correct the issue themselves. That's generally a reasonable thing to include in a lease. So if a tenant is going to withhold rent, in addition to writing that letter, the tenant should look at their lease first. And if a tenant wants to make the repairs on their own or wants to pay someone to make the repairs, the tenant should check their lease for provisions about that as well. It's not to say that every lease provision that says a tenant can't make repairs is going to be valid. For example, if the lease says that the tenant can't make repairs until the landlord has had 1 week, and we're talking about a lack of water, the court is not going to require that the tenant give the landlord a week to restore water. But the tenant should definitely look at the lease to see what the lease says about that. And again, this is one of those areas where communication is key. If you as tenants and landlords can talk to each other about these issues, talk about the status of these issues. For example, I'm the landlord, I'm sending someone out, but they can't be there till Tuesday. Or the tenant, hi, I haven't heard from you in 2 days. Can I have an update? Those things go a long way in helping to resolve things quickly, because when you need court intervention to fix a condition like this, it's usually not immediate. So since you're going to be waiting at least a little while either way, the best thing to do is for the landlord to communicate with the tenant and vice versa. Next slide, please. So these are some resources that we've put together for you. We want you to have information about the Federal CARES Act and the New York State guidance as well. The AG, the Attorney General of New York, has put together updated information about COVID and landlord-tenant law, and it's at that second website right there. And again, these materials are going to be distributed to you, so don't worry about writing anything down quickly or trying to copy it or remember it. Additionally, there are 2 websites that have administrative orders and executive orders. For the non-lawyers, that is quite boring reading. I would not suggest you go there and read that for fun. We spend a long time reading those and analyzing them, and it often takes a little bit. So maybe skip over those. The last link on there is probably one of the most important. It's the mortgage assistance program. So if you're a landlord and you have a tenant who's behind on the rent, you can refer them to that website. And if you're a tenant and you're behind on the rent, you can go to that website and look for information about applying for back rent. Next slide, please. Okay, a couple other pieces of information and resources for you. The Bar Association of Erie County has the Volunteer Lawyer Project Housing Helpline. That's the first number. You can contact them with your questions about housing. You can also contact Neighborhood Legal Services with your questions about housing. I'll put the number in the chat right now. And when you do that, we usually are able to do an intake that same day and get you the legal advice that you need about your housing situation. The 8th Judicial District has a help center. It's on West Eagle. It's relatively near City Court and kind of right across the street from State Supreme Court. And they have resources there for people who can't get in touch with an attorney or aren't working with an attorney. Additionally, the National Housing Law Project has great information for landlords, tenants, anyone renting or leasing units. They also have specific information about COVID and how that's affected this process of renting and leasing, showing units, listing units. They have a lot of great detailed information. Housing Opportunities Made Equal, also called HOME, is a great resource, especially if you feel that you're facing housing discrimination. If you have questions about whether you may be a victim of housing discrimination or whether what your landlord is doing falls under a violation of the Fair Housing Act, we'd encourage you to get in touch with HOME. And the New York State Division of Human Rights also has a fair housing office. You can get in touch with them regarding a specific complaint, or check out that website to see more information about your fair housing rights. And next slide, please. All right, so we've had some questions throughout the presentation that we've tried to get to, but if you have additional questions, please go ahead and put them in the chat, and also we'll check in on the Facebook Live page to see if we have more questions there too. I do see one that just came in. Are these resources specific to Erie County, or do they apply to Niagara County as well? Some of the resources are Erie County specific. Others include the entire 8th Judicial District. If you're looking for Niagara County specific resources, please contact us at Neighborhood Legal Services. We serve Niagara County as well, and we have specific resources for Niagara County. If you want to go to our website, that's fine too, but if it's something you'd rather talk out, give me a call and I can let you know what the resources are in Niagara County that you might need.
Thank you, Caitlin and Chris. This was incredible. And I also want to thank all our participants, both Facebook and Zoom, for asking really thoughtful questions. We've been asked about the Housing COVID-19 Edition virtual legal clinic since September. Actually early summer, actually. So we're happy that we were able to have this session. We did have a couple more questions that I didn't put in the chat because I didn't want to interfere with the questions that were coming through Zoom. And so I did write them down. One of them is, does the moratorium protect residential tenants from utility service interruptions due to non-payment?
That's a great question. Unfortunately, we've seen an uptick, but Chris's office and my office, we've seen an uptick in what we refer to as landlord self-help, meaning a tenant doesn't pay the rent and a landlord cuts the utilities. This is not acceptable. Landlords cannot cut utilities because a tenant hasn't paid rent. Landlords can't do that during COVID. They can't do it after COVID. They are never able to do it. There are severe penalties that can be put into place, including monetary fines. And if a tenant is without utilities because of landlord failure, that tenant should contact Neighborhood Legal Services or a volunteer lawyer project, and we can open up a case to address that. Just a quick note, don't call both of us because we can't both have a case open. We can only have a case open at one office for a particular client, but you will be assigned an attorney to work with you, and the attorney can figure out the best course of action with you for how you can get that addressed. Landlords should not be resorting to self-help if there's a non-payment of rent. That's just because most evictions are stalled. That's not an okay thing to have happen.
Thanks, Caitlin. And the last question that I have, what should I do if I think my landlord is violating the moratorium?
So I would say if you think your landlord is violating the moratorium, I'm wondering, without a little more information, I'm thinking maybe by filing in court, or I don't know if the person who asked the question has the ability to give a little more information. If you think your landlord is violating the moratorium by filing in court, you should, either way, you should contact Neighborhood Legal Services or Volunteer Lawyer Project. But there are some cases that are allowed to go forward in the courts. So if your landlord's trying to file an eviction proceeding and the court gives your landlord a hearing date, it's because the court has decided that this was an essential matter, which means it falls outside the bounds of the CDC eviction moratorium and the Tenant Safe Harbor Act in terms of preventing people from filing. So you may still have those defenses under those moratoria, but your landlord can bring you to court and get a hearing date. So just because you have to go to court doesn't mean you've lost the case, but it does mean that your landlord presented something to the court that indicates this is more than a garden variety eviction. There's something going on here that's more than just non-payment of rent or non-payment of utilities. Maybe there's police activity. Maybe there's drug activity. There's no hold on evictions if there's drug activity, or like I had mentioned before, conduct that is unsafe to other tenants or to the property. But if you think your landlord is violating the moratorium by cutting your power or other things, contact us and let us know. As you might know, Governor Cuomo suspended the collection of late fees during the moratorium. So while the CDC doesn't prohibit your landlord from charging late fees, the state does. It's one of those situations where New York is more protective than the federal moratorium. So if you're paying your rent, but you're not making full payments and your landlord is tacking on a lot of late fees, and you feel that, you know, this is illegal under the Safe Harbor Act, give us a call. If you just want to know your rights, if you're not sure about, you know, where a situation is heading, you don't have to wait until you have court papers to contact us. You can contact us at any time. And a question about the slides too. Yes, we are going to make actually slightly updated slides available after the presentation, and you'll be able to refer to them, and they'll have our contact information too. We'll make sure that everybody gets those.
One other note about violations of the various moratoria. These rules are complicated. There are landlords that make mistakes without meaning to. They're complicated and they change frequently. I'm having a hard time keeping up with them because the changes are coming from different sources and they're happening almost every day, it seems. So it's possible that a landlord simply doesn't know what the rule is or how the rule applies. I've been in that situation with a landlord trying to assert a right that they don't have, and I know it's tricky, but if you can communicate with them, that is that can go a long way, rather than, you know, jumping to your guns and being defensive. There was a comment earlier about why there aren't any inspections done before tenants move in. And I just wanted to say the reason for that is because there's no law that says it has to be done. Now, there can be rules made in Erie County or in the city of Buffalo or whatever other jurisdiction. And if that's a change that you feel strongly about, if you've ever moved into an apartment that wasn't up to shape, then you should contact your representatives at the county or city level, and you should reach out to organizations that are doing work to organize and sort of get this message out, including Push Buffalo, People United for Sustainable Housing. We mentioned Housing Opportunities Made Equal earlier. There's a group called the Partnership for the Public Good, PPG. So you wouldn't be the first person to have that thought, and if it's a change that you want to see, there isn't anything that is preventing it from happening.
Thanks, Chris. I can't thank you and Caitlin enough for sharing this valuable information. As I looked through the chat on Zoom as well as Facebook, everybody felt that this information was very informative and is very timely. As referenced earlier, everyone who registered for this session will receive the slides as well as the document What We Know About Evictions in New York State that Caitlin and Chris has been kind enough to share with us. If you attended through Facebook, you will be able to access this as well by sending an email to gsmallwood@sayyesbuffalo.org, or you can just post a comment right on this live feed requesting the PowerPoint as well as that one-pager notice. Thank you again to a Volunteer Lawyers Project for helping to put this session together for us. Again, here are the numbers to contact if you do have questions related to other topics that weren't addressed today. And again, thank you, Chris and Caitlin. We probably will want you back again. I know there are probably some other questions that come up as we get closer to the extended date for the moratorium expiration.
Sorry, Jelena, I do see one more question that I can answer quickly.
Yes, absolutely.
We get this one a lot. Is there financial assistance for small landlords outlined in the CDC or New York State recent COVID orders? There is not in those recent things that you're referring to. We are hopeful that there will be relief for small landlords. We are keeping an eye on that constantly, and we will post information about that on our website as it becomes available. We know there's a lot of landlords out there hurting, a lot of tenants out there hurting, and you know, our goal is to keep these landlord-tenant relationships. So we will we'll definitely post that as we get it.
And landlords may be as interested, small landlords may be as interested as tenants to look into the assistance fund from the Live Well Erie program that can provide assistance to tenants that are behind. I believe the funding comes through the CARES Act, and that is financial assistance, rent that is paid directly to the landlord if the tenant qualifies in order to satisfy some of their obligations.
Great. Thank you both for catching that last question. We want to make sure we attend to all our guests who joined us. So thank you again, everyone. We'll be bringing you additional virtual legal clinic sessions that are based on topics that are driven from our community needs. So stay tuned and follow us on Facebook at BPS Community Schools as well as BPS Parent Centers. You can also find this information on our sayyesbuffalo.org website. Thanks for joining us.